Hi there. I'm Elaine
Hi.
Lindsay, and I'm your moderator. I'm here today for Recovery Academy. We're going to be discussing, Mental Health Act and issues of disclosure. And I'm here with the lovely Catherine Corey, who is, of course, the Recovery Academy founder, administrator. She's a lot of wonderful things to a lot of people. Catherine's going to take this very deep and involved topic and make it a little more approachable for those that really need the help. If at any point, Catherine, you say something that I think is a little too advanced, I'll jump in as a layman and see if we can maybe break it down a little. So on that note, I will give it to Catherine to take away.
Well, thank you, Elaine. And yes, it is kind of complicated. And one of the reasons that I really wanted to talk about it today was if I go back about 10 years to my son's first hospitalization.
Right.
In through the emergency room. And I remember standing in the parking lot afterwards going, I don't understand. I don't understand. I've just heard about forms and I've just heard about some sections, and I've just heard, I don't really understand what's going on. What I understand is that my son is in the hospital in a locked ward, and he's not allowed to leave, and because there's been some challenges, I'm not actually allowed to see him. But I am going to receive some information about what's going on. I'm going to have to meet with the social worker and the doctors in a couple of days because they're going to do a bit of an assessment. So that was my first kind of, oh my goodness, what's a form? Because there seemed to be some feeling on the health professionals that I would understand what they were talking about.
Absolutely.
And I didn't. I really didn't. And over the course of the last 10 years, I've had to deal with a lot of parts and pieces of the legislation that gets covered when you have a young person who has a mental illness.
Right.
There are actually 4 or 5 pieces of legislation that come into play. There's the Mental Health Act, and these are provincial legislations, and I always have to say that because in our system, it's provincially legislated. So even though we have across Canada a kind of an idea or a feeling that we have the same health services in each province and the legislation is similar, it's not the same. So I'm only speaking about what's happening in Ontario. So if you're in BC or if you're in Manitoba or Alberta, the legislation can be different than what we have here in Ontario. So you really have to look at them. But at least it gives you an idea where to start looking at legislation.
Right.
So we do have the Mental Health Act, which I'm going to talk about a little bit, and pieces of it which, for me as a parent and my experience, I came across. We also have the Healthcare Consent Act. We also have the Substitute Decision Act. We have the privacy, I always go, that's PHP, it's the Health Information and Privacy Act, and that was a more recent legislation which creates a lot of challenges for parents. So I'll talk a little about that for sure. And then there is, if the child happens to be under 16, there's the Child and Family Services Act, so that there's also legislation under there. I'm not as familiar with that because I entered the system when my son was 16, not under 16.
Right.
But I am very aware that there are children under 16 who have significant mental illness and mental disorders. So I'll talk a little bit about what that legislation happens to cover. Okay. But it is part of, because there is all that legislation and a few other little side things too, that it becomes complicated for parents in terms of interacting with healthcare providers.
Well, yeah. I mean, you've already, that's 5 different things in the first second that you're talking about it. Wow.
Yes, yes.
So let's just get them clear, and we'll make sure that it's available for people after. But we have the Mental Health Act.
Yes.
We have the Healthcare Consent.
Yes.
We have the, is it Substitute Care Consent?
Yes, substitute decision makers.
Decision maker.
Yeah.
Okay. And the Health Information and Privacy Act. And then for those under 16, they also have the Child and Family Services Act.
Yes.
Okay. Perfect.
Okay, so under the Mental Health Act, the Ontario Mental Health Act, what I was most concerned about, and probably what parents are most concerned about, is the criteria and process for admission to a psychiatric facility. And it's not just a psychiatric facility, it's also what we call a Schedule I hospital. And a Schedule I hospital has a specialized psychiatric floor or unit that has the capacity to lock down.
Okay.
Okay, so there are some hospitals even in our region that have some mental health beds, but they wouldn't be considered a Schedule I because they don't have the capacity to lock down a unit.
Okay. And that's an important differentiation.
Certainly, it is. It is, because if you are actually looking for hospitalization for a loved one and you happen to go to a hospital that's not a Schedule I and your loved one is not volunteering to be hospitalized, then they would need to be transferred to a hospital that they could be involuntarily hospitalized, which is another thing that comes up.
Yeah.
Yes. So under the Mental Health Act is the criteria and the process for admission, the appeals process, under what conditions treatment can be imposed, so that's an involuntary versus a voluntary, who can see the patient's records, community treatment orders. It covers quite a bit of that, as well as the other thing that I came across is the legislation for police taking action.
Okay.
Is also in the Mental Health Act, which is around the criteria and process for admissions. So the Ontario Healthcare Consent Act is basically your right to refuse treatment.
Yes.
And that treatment cannot be administered unless consented to by the individual or a substitute decision maker.
Right. And for someone who has, say, a 17-year-old and this is their first time, they're already going to be bombarded because they don't have that substitute decision maker consent.
Yes. And again, then you get into the complications, because if they're deemed to be not capable of giving consent, then in the substitute decision maker, there's a listing or a protocol that would put certain individuals under those circumstances as somebody who could make decisions on their behalf.
Oh, okay. And is that all? It sounds like it's an awful lot of forms, as you say. Is that something that can be handled like all at once? Those three things, the forms that you have, and in the case of, say, a family member bringing in a 17-year-old for the very first time, can that be granted, the substitute for care for the decision maker? Can that be handled right away?
It can, but again, it's based then on capacity.
Okay.
So if the young person is deemed as not being capable of making decisions for themselves, then for me, like in my particular case, when my son was hospitalized, the first time he was 16. So at that particular time, as soon as they're deemed to be incapacitated or incapable, then I'm the next one on the list as a parent, a custodial parent, as being somebody who could make decisions for him.
Okay.
So I could authorize treatment. Now, what becomes challenging is that when they're deemed to be capable of making those decisions, then I'm no longer able to make them for them. So then the information request wouldn't come to me anymore.
Right, right.
Okay. So, and that did happen in his particular case. He was in hospital for a while, and then when he became an voluntary patient, so that means he's no longer on a form, he's no longer deemed to be incapable of making those decisions for himself.
Right.
he can actually check himself out of the hospital, which he did. Now, because he was making those decisions, then the hospital and the healthcare providers are no longer obligated to give me any information at all.
Wow.
So they didn't need to give me any information that he discharged himself. They didn't need to give me any information about his medication or any follow-up treatment or any planning or anything like that, unless he had, given consent for that.
Right. Right.
And sometimes there's conversations and sometimes there aren't about that, because then they fall under the legislation of the Personal Health Information and Privacy Act.
Right.
Okay. So it's kind of like they're built on each other.
Yeah. Yeah.
Yeah. So it depends on where they happen to be. So it becomes really important, the issue of capacity.
And what, maybe outline for people, how fine a line is there? What is considered appropriate capacity, and where is the line drawn? When do they become incapacitated?
Well, when they become incapacitated, and I can go to the I have a little, let me see, some information on that.
Because I think that's useful information, because even if you're just sort of beginning to tread this road, I always believe that having more knowledge is beneficial. So if people can, have the ability to at least understand where they might fall, or, if their concerns are going to be held in the same esteem, say, as the mental health workers that they're going to encounter.
Well, as a capacity is the ability to understand the information that's relevant to deciding whether to consent to the collection or use of information.
Okay.
And the ability to appreciate the reasonable, foreseeable consequences of giving it or not.
Okay.
Now, what they will assume is that if they have them on a Form 1,
mm-hmm.
okay, which is an involuntary hospitalization, and the physician is going, okay, we don't think they have the ability to make the decisions about their care, so
right.
we're going to hospitalize them involuntarily. Then it's again at that particular point they're going, well, it's pretty clear to us that they don't have the capacity.
Yeah.
To do that. Now, when they're no longer on a form, it's also then assumed that they do have the capacity,
mm-hmm.
even though for many of us, even as a parental thing, where we're going, no, but we don't really think that they have the ability to look at what the foreseeable implications of this will be. But again, it's clear when the doctors sign off, and there's lots of gray area in between. And so if it's not clearly signed and documented that they're not capable or have capacity, then it's assumed they do.
Wow.
Right? So that is one of the challenges of mental illness, is that that moving in and out.
Yeah. Yeah.
Or what we would consider capacity, but only and if a professional deems that they aren't, or you go before the courts, and if they have a significant mental illness,
mm-hmm.
and it's deemed that they won't probably have any capacity for understanding,
right,
then you would have something put into place. But otherwise, it's kind of an in and out. And in my case, it's been an in and out. So there were some days when I would say he wouldn't have the capacity, but without a professional saying he doesn't, it doesn't come into play. It's always deemed that they have the capacity.
So the default would be capacity.
Absolutely.
Okay. That's got to be tough as a parent.
Yes. Yes. It is tough as a parent, particularly, as I said, because there wasn't really anybody who sat down and explained to me that there's a number of legislations, and one kicks in and the other one doesn't kick in, and how does this interplay with this, and how do we do this? And a lot of it is left to interpretation of those people who are using it.
Yeah, well, the other thing that you know, you've been deeply involved in this for more than 10 years now, and you do have an incredible understanding of all the mechanisms and how they flow together and how it flows in and out. For the average person coming into this, and as a mother myself, I believe that the parents have to have a superior level of knowledge of their child, their adult child, their young teen, than any worker at a hospital who's only seeing them in that situation. Like, where does that backstory or that prior knowledge, where does that fit in? And do you get to discuss that with the doctors, or does it have any weight in the consideration of capacity?
It does, and it doesn't. It depends on the circumstances. It depends on the actual healthcare providers. Right. It depends oftentimes as a parent, because one of the things that for me as a parent depends on your reaction and how you happen to become involved. And I go back to my first experience. It became evident to me that what was going on, the thought patterns, the thinking that was going on, and the behavior with my son was an emergency. It was, to me, something really needed to have happen. He needed to be assessed. The things that had been in place before were not working. Now, I had enough of a relationship with my son that when I said to him, I said, you know what's going on here? You know, you're ill. We really need to go to the hospital. He went to the hospital voluntarily with me.
Yeah.
Now, the challenge was, because I'd had a lot of training, and I was dealing with his illness, not necessarily with the behaviors that led up to it. It's very much like, okay, I'm a parent. I'm thinking that he's really ill. I wasn't having the reaction that they were expecting me to have.
Okay.
And so I had to jump through a couple of other hoops. But sometimes as parents, you can go in there and you can look like you're calm and you're not.
Yeah.
Or you can be overly, aggressive because you're absolutely terrified and afraid. I mean, we're having a response to a crisis, and each of us, operates a little bit differently. And again, it's the perception of the people that you're interacting with, whether or not you're being appropriate, you're not being appropriate. And unfortunately, in mental illness, that also means whether or not they believe that you're a contributing factor or not.
Right, right.
And if they believe that you're a contributing factor, then they're less likely to give you information and have you part of the process.
Of course.
Than not. And again, a lot of this is on perception as to how helpful or not helpful a situation is. So, I mean, when my son was actually taken up to the unit and discovered that he wasn't going to be able to come out, he was furious with me.
Well,
and so they had decided during his hospitalization that it wouldn't be appropriate for him to see me because he was so angry with me, and so I wasn't helpful in the situation. Now that was very, very difficult for me.
Absolutely.
And also, I didn't really understand. Because he hadn't been hospitalized before, about that kind of access, that I would be able to visit him, that they could actually keep me out.
Yeah.
That it was a locked unit, and therefore not only could he not come out, but I couldn't get in.
People couldn't go in, absolutely.
Yeah. So, I mean, that was quite a bit different, and it was based on his reaction. And of course, it can also be based on a parent reaction, and it's the providers. They're needing to do what they need to do, and they make decisions on that. Now, as you said, in terms of information, they certainly want to know background and history, and because they were also looking at not just mental illness, but they were also looking at what we consider some other biological possibilities.
Right.
There are hormonal or tumors or other kinds of things that will also create some behavioral challenges, and I've certainly heard of those. So that they needed to rule out all of those as well. Also, drug use will bring upon, which is one of the things that they were also looking at for him. So there's all of those kinds of things that they'll be looking at. So they'll want some amount of family history. But they also need to go on their own observations. their own observations and their own interviews and things like that. And so oftentimes I say, and I had no idea even at that particular point in time, that in the DSM, most of the diagnoses take at least a 6-month observation of certain.
I'm just going to stop you there, just so please explain DSM for everybody.
Is the Diagnostical Statistical Manual, so it's the book that, you know, the doctors, the psychiatrists go to when they're looking at diagnosing a mental illness. Or indeed, I mean, substance use disorders are also underneath there, so, you know, your concurrent disorder. So that's the manual that they use. And again, in those early days, I was kind of overwhelmed because they were talking about certain illnesses, and I really didn't have any idea about any of them. I was looking at it really from a behavior point of view.
Right.
And you know, going, you know, please fix them. Can we, you know, give them something, or, you know, find out what it is. And, you know, and I remember thinking at the time, hoping that maybe it was a tumor that was causing this.
Absolutely.
And it would be easily explainable. Yeah. So throughout that particular process, I was getting a fair amount of information, but once he became a voluntary patient and he left, they were under no obligation to give me any other information. So, and I would say, like, with this was, they didn't need to give me information about follow-up appointments, about medication that he was on, or really anything at all. They did give me a courtesy call to say that he checked himself out, and they gave him a taxi chit. So I didn't really have any idea where he'd gone, or where he was, or what was happening from there. So, and that was particularly challenging because that was the first time it hadn't really occurred to me that I wouldn't get information.
Well, no, you were his mom.
Yes. And I said, yeah, he was 16. I didn't figure I was out past that. But again, without consent and his consent, and one of the challenges in the system is sometimes they're not asked. And again, the fallback position is, generally speaking, that they wouldn't want to give consent.
Yeah. Yeah.
Which for many of us is a challenge, because you're thinking, well, if they had any other illness, the fallback position is that certainly you would want your family to have consent.
You usually want somebody else involved, and for me, just as a layperson, it's just very scary as a mom to think that my 16 to 20-year-old child is expected to take all of this on themselves, whether or not we believe them capable. In many instances, I'm sure, some are, but many are not. And then what happens?
Yeah. So it is, and I always say, under the Personal Health Information and Protection Act, you can only, and I would say in the Section 20 there, for the healthcare providers, and I have to say this for them, they can only give you out the health information when the client is deemed capable, when the patient or the client gives consent.
Yeah.
Or in the circumstances, and I would say, when they think the disclosure is necessary to eliminate or reduce significant risk of serious bodily harm to individuals or the community. That's the only time that they can give out the information. And again, that's one of those tricky places, because if they've deemed them as having capacity, then they don't think that they are a risk.
Yeah.
Right? So it becomes tricky.
Yeah, it's got to be tricky. It's got to be tricky for the health workers as well, because you're walking quite a tightrope, I would say, on either side.
That's right, because there's serious consequences if they give out information that they shouldn't give out. So even if they're feeling like, I want to be supportive, but there are serious consequences to them if they do give out the information when they shouldn't. Now, I always said there are certain ways in which you can, as a parent, operate a little bit, and there was a couple of people that mentioned to me, if you mention hypothetical situations,
yes,
they may be able to give you general hypothetical answers.
Okay. Well, actually, yeah.
That's a way of getting around it a little bit.
Well, at least getting some information. Yeah.
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 So it can't be specific to the person that you're involved in, but you could get some information. And I said, and for me, sometimes that was a challenge that, if a person was in this situation, would they generally have a follow-up appointment?
Right.
What were those kinds of general things?
Yeah.
Would they
Yes.
be discharged with a prescription? Would they be,
what
those
would
kinds
happen
of things?
next?
And they can generally answer yes or no, but not necessarily the specifics to your particular individual.
So again, it's sort of the chicken and the egg thing. Like, how do you prepare for a first time when the fact that it is a first time often means there is no preparation. You can't, have any idea of where it's going to go because you had no idea you were getting there.
Yeah. So this is just meant to be able to explain a little bit. So then, of course, then you go, okay, well, what if, we have the Substitute Decision Makers Act. What if I managed to get a power of attorney?
Right.
A power of attorney for personal care. So then I would have access to this information. Right. However, on those ones, those only come into play, again, when they're not capable.
Right. Right.
Okay? So I never really went for that because that's a legal paper that I'm still next of kin, so I'm getting it anyway.
Right.
When they're indeed not capable. So I have a paper that says when they're not capable, I can make decisions.
Right.
But I don't really need one as the mom.
Okay, and that's a good distinction to make, and the fact that even though that consent as decision maker, you're going through another act, but again, you just said that only comes into play when they are in fact incapacitated.
That's correct. Now, there is legislation under the Substitute Decisions Act that is helpful in some situations, and it's called the Ulysses contract.
Okay.
And the Ulysses contract is basically saying, so that, for instance, now because my son's been ill for quite some time, when he's capable, or if somebody has another serious mental illness, or even things like Alzheimer's or dementia, when they know that they may come to a time when they will potentially, because of their illness, resist treatment.
Right.
They can actually have it in a contract saying this person can make these decisions for me in this particular case, including treatment choices.
Right.
I'm giving my consent in advance.
Right.
Because I know that I have this illness and I, may come in and out of being capable or not capable. So that just makes it clear, and here's what my wishes are.
Okay, well that's good to know, and wow, it puts
fairly along the ways, and you're not necessarily going to get that with your adolescent
or
your child. But it is one of the things that is a possibility down the road. And for some of us, if you're looking at long-term illnesses, where they can become incapable and quite ill when off of medication, or sometimes medication doesn't work, or circumstances come up, those kinds of things, and that you have that conversation with your loved one, then that is an option of putting something into place. Because again, out there in terms of healthcare providers, it's one thing when they're young, but what about when they're 30 or 40?
Yeah.
Or they may need somebody else, not you as the parent doing it. You may need to have somebody else in that particular position. So there is the benefit of having legislation to do that as well.
Wow. It's an awful lot to think about. It's a really deep and involved subject, and I can't believe how fast time has flown. We had planned to limit our time to about a half an hour each, because it's a really heavy subject to be taken in, and being able to access these videos and re-access them on the Recovery Academy should be very helpful. Catherine, did you want to take a look at the Privacy and Health Information contract, or excuse me,
I I wanted to talk about that a little bit
Yeah.
in terms of because I said in my experience it's been one of the biggest challenges, and I think I've said to you before too.
Yeah.
When you have somebody and they're deemed capable, it means then you don't get the information about the doctor's appointment or the medication or some of those kinds of things, and that can be problematic because we know as family members. Best outcomes come when families are involved,
Yeah.
and a lot of that is because we can do some support. Now I know with my son, one of the challenges is even remembering about appointments, and it's one of the things that I still do. I mean, he gives them to me now. I don't need to get them from the health practitioners, and I put them on my calendar just as a reminder, as something that's helpful. So that would be one kind of place. Now what I've come across and what I advise on it is there is a form from the Ontario government when we talked about the informed consent.
Yeah.
And informed consent is the best. So if they have, capacity or they're capable, or you have that conversation with them so that you're not necessarily needing the healthcare provider to, because usually it's the health care provider who says, are you going to give them consent? But you
Right.
also have the provincial form.
Okay.
That if you fill it out, and I think I may have it here so I can share it with you. I don't.
Oh, good.
I may. We'll see. We'll see. I mean, I'm going to send you we'll have the PDF link to it anyway.
Yeah. Yeah.
Right?
Yeah, we'll make sure that all the links are available if there are forms that you can have a look at. Just to be able to familiarize yourself with what is available, we'll make sure that all those links are tied to the page where you're going to find these videos.
Now I might not have it. Can you see that?
Yeah, it's not really large.
No.
But as we say, we're going to make sure it's available so that people can actually get an idea of what they're looking at.
Yeah, so basically it's a form that you fill in that you're giving permission. So you would have your loved one, your name there, and that they're giving you permission to access particular information. Now, one of the challenges that healthcare providers have is when they're asking for the consent, they're usually thinking it's full disclosure.
Right.
And I look at it this way, as a parent, yes, I would like full disclosure, but I would rather have some disclosure than none.
Yeah. Yeah.
And if they're going to be released from hospital to my home, then there's certain things that I need to know.
Absolutely.
Very much like if they were released to someplace else. And generally those are around medications, appointments, their health provider's name, and if there's some kind of a treatment plan. So things that I may need to look for in terms of relapse.
Yeah.
Or things that there may be some challenges around. Now on this particular form you have a possibility of putting those in specifically.
Oh, good.
And I think for most health providers, at least the ones that I've talked to, they're much more open about giving specific information that's been agreed to than generalized information.
Right, right.
Right? Because sometimes they think as parents we want to know what they say about us.
Yeah, yeah.
Okay, and I think there's some curiosity around that, but if you're giving me a choice between the whole file or no file, I'm going with here's some of the pieces that would be really important for me.
You want to pick your battles.
Yeah, absolutely. So this is the form that can do that, and with a witness, you can present that to a health provider.
Okay.
And that means that they have the signed off legislation. Now again, and I know this between health providers, that's not necessarily a guarantee.
Right.
But it's at least a step closer, and it's something that you can do as a family member to be proactive.
Yeah, yeah.
And we are working in the region to be able to standardize some of that, and to educate health providers and saying, you know what, having family involved if possible. And if it's going to be a positive experience, because as families we also have to go through our own processes. There's a lot of things that I need to learn along the line. But this is definitely one of those things where if you can ask for specific pieces and your loved one who's ill can give consent to that and will sign off on it, then at least you have a stepping stone to being helpful and for them taking over their care. Because I used to say, okay, so one day they're not capable of making any decisions, and then the next day they're capable of making them all. I said, well, sometimes we all need a little help in starting to make really good decisions for ourselves. So I think this is a tool that can enhance recovery. And it will encourage families to stay involved.
Oh, and definitely, and having positive experiences with family members and having more help around you can only be helpful.
Yeah. So that for me is an important piece, and definitely stays within the limits. And again, that whole idea of making sure that the person who is ill also has rights and has a feelings of making choices about their own care and what's happening to them. And even for children and adolescents, I mean, it's built into our system. And as hard as it is as a parent, that is one of the things in terms of recovery, is really supporting their choice-making abilities and really, having tools and ways to be able to discuss how that happens and how that's supported.
Right. And allowing them to have those choices, because like you say, it's often very difficult as a parent to let go and not think you might know what's best, which isn't necessarily the case.
Well, and it's scary when they're vulnerable and when you see them as being vulnerable. Yeah, it is. And so, yeah.
So what I'd like to share, if anyone has any questions or concerns, or if they'd like more information, we will have the PDFs and links to other areas that can be of use. The next video will be coming up. And what is our topic on the next one, Catherine?
Concurrent disorders.
Concurrent disorder.
Another challenge in and a concurrent disorder is a mental illness and an addiction issue.
Mental illness and and are there other types of concurrent disorders, or is that basically?
Well, that's in Canada. That's the definition of a concurrent disorder.
Thank you.
We have co-occurring, and sometimes then you would talk about learning disabilities and mental illness.
Yes. Okay.
So that's a dual diagnosis. Like they talk about that. So we will have a session where we talk about dual diagnosis when you're talking about cognitive dual learning disabilities, or it would be things like autism or ADD with a mental disorder. With a mental disorder. Yeah.
Okay, these are very deep topics that I think it's really, for me, exciting to see that more and more information is getting out there. Catherine, you're definitely a leader in the field, and I love the fact that you keep soldiering on to make more information available to the family members and other caregivers of people that are in crisis and people with mental health and addiction issues. Everybody, be sure to check out Recovery Academy. There's lots more there for you to learn. Thank you so much, Catherine Corey, founder of Recovery Academy, and wonderful administrator, and we'll see you again on the next show where we'll be discussing concurrent disorder.
Thank you.
Bye-bye.
Bye now.